Hello, everyone. Thank you for joining the Lead Generation World Live podcast with our favorite guest, Eric Troutman from the Troutman firm, Troutman LLP firm. Sorry. It's always a pleasure. Yes, there we go. Although we do need to get you a new one of those. I think that's
it's just got some stains on it, man. It's just tea.
Just some coffee stains. We'll get started here in just a few seconds. We want to give some people some time to join before we start getting right into it, because as people know that have seen this broadcast before, we get right into it and start talking about all kinds of stuff and cut out all the fluff. And so we will get started here in just a moment. Just remember that if you're joining on YouTube or LinkedIn, that you can comment and we'll see the comments, and I will be able to ask some of those questions that you may have for Eric. So the best thing that you can do, and the most important ask that I have of you, is to participate and ask questions. This stuff usually costs hundreds and hundreds and hundreds of dollars to get questions like this answered by someone like Eric. And we've got him here. He donates his time. Like I said, which I alluded to, is expensive. I just ask his clients, but very, very much worthwhile. So ask questions, participate, and we'll be able to get the most out of this next 30 to 45 minutes. I don't think we're going to take all that much time because, well, we'll see. We'll see what Eric has to say about that. But I also, before we get started, want to mention that the one and only conference that is dedicated to calls, pay-per-call, and sales calls, outbound strategies, coming up in August. Yeah, it's a little ways away. It's called contact.io, but registration is open. It's at its lowest price, and so I would take advantage of it now. Don't wait. So many people, it's crazy, Eric, how many people wait to register for a conference until it's the highest price, like 2 weeks before the show. They're like, okay, I'm finally going to go. Now, I kind of get it with most shows because most shows don't have a refund policy, but we have a refund policy all the way up to 14 days, 2 weeks to the show. So buy the damn ticket now, save $600. And if you can't go, just make sure you let us know 2 weeks before the show and you get a refund, a full refund. Stop wasting money, people, is my point.
It's a pretty good deal. Yeah, that's smart.
Yeah. Because listen, conferences are expensive. Well, there's no doubt about it. You have to take advantage of this early bird price. And like I said, we're one of the few that actually have a refund policy. So, okay, enough about that. I think I killed at least 3 minutes there, so not too bad. I wanted to bring on again Eric Troutman because I thought there were some really interesting things that happened over the last, 15 days, or I guess 30 days now. And really the way I saw it, and sort of just to give a summary and lead right into it, was around AI, the definition of robocalls, disclosures, and then how those three things tie in, I think for me, which I thought was most interesting, into text messaging. So I thought that was let's dive in. We had a senator named Frank Pallone?
No, he's actually not a senator. Pallone. He's a representative.
Okay. You're here to correct me on everything I say wrong. So, okay, perfect. We're getting off to a good start. He's proposed some changes. Give it to me. Give me the summary of what those changes are.
Yeah, so the TCPA right now is being looked at by Congress. Congressman Frank Pallone has sponsored. He's got a few co-sponsors, all Democrats. A bill called the Do Not Disturb Bill. By the way, we got some rock music going. I kind of like this. This is pretty good.
Yes, sir. We do have rock music going. Hold on.
I can fucking rock at the same time, man. I can do this. I just
all right, rock on there. Go for it.
Yeah. So the Do Not Disturb Act has been proposed. It is a multifaceted bill, guys. Really, really important. A lot of different pieces to it, impacting both the TCPA and the TSR. Well, frankly, there's a lot of pieces. I'm not even sure what the headline is. One of the big headlines is AI is going to be regulated for the first time ever at the federal level. And of course, the TCPA is the statute that's going to bring it to you. The TCPA is like always at the center of so many legal developments. If this bill passes, it'd be the first time ever that a disclosure would be required before you're using outbound AI for marketing or informational purposes. You'd have to tell that consumer, hey, this is AI talking. We can unpackage that here in a bit. That's one piece. Another piece, maybe more pertinent for the non-AI users in the room, is that the federal government is going to define the word robocall for the first time ever, potentially. And it's an incredibly broad definition. I did a breakdown with Isaac on a different webinar you can see on my YouTube channel, kind of going through all the little nuances of it. It's incredibly nuanced, but bottom line is it would be much, much broader than the current definition of ATDS. We'd be looking at basically any call that you're making is going to be a auto dial call unless you're actually picking up a phone and dialing. And even that might be triggered under this definition. I think that definition is going to be rolled back. I don't expect it to pass as it is written, but that's currently what's being looked at. And then as you alluded to, text messages. Text messages are going to be brought within the scope of the statute, but not just text messages, right? When you're thinking about like an SMS message, like a regular old outreach that you think of as a text message, that is one thing, but you guys just have to understand critically, this is an opportunity for the Democrats, for Congress to try to regulate not just text messages, but OTT services like WhatsApp as well. If this bill passes, do not disturb. Any communication platform on your phone, any app-based communication platform, any communication, including seemingly even email, which is crazy, even perhaps email, is going to be regulated now as a potential robocall under the TCPA. So you've really got to pay attention to this. Now, I'm doing this like for this purpose at a really high level. I'm just giving you some knowledge, some little seeds that might grow. You're going to have to go research this or take a look on tcpaworld.com. We've got it all broken down for you, but really, really big changes potentially coming out of Congress.
Okay, let's just target that. And yeah, you're absolutely right. You can check this out on tcpaworld.com. We'll get that up here if you didn't hear it. But let's talk about that robocall and ATDS redefinition. According on your website, you've got it nicely detailed out. The term robocall means a call made or a text message sent using equipment, whether hardware, software, or a combination thereof, and including an automated telephone dialing system that makes calls or sends texts. It stores telephone numbers or telephone numbers produced using random or sequential number generator. And then I guess this is two, using an artificial or pre-recorded voice or an artificially generated message. And then for the purpose, let's see, the term robocall does not include a call made or text message sent using equipment that requires substantial human intervention to make or send a call or text. So they just threw that one in there just to really make things confusing for us all, because who the hell knows what substantial human intervention is. Seems like that could be arbitrary. But tell me the difference here. Obviously, it's the inclusion of artificial voice or text, right?
No, that's not the issue.
No?
So a couple of pieces. First,
yeah,
automatic telephone dialing system is now will be struck from the TCPA. There'll be no definition of automatic telephone dialing system. Yet, as you just read, that would be tucked in, that phrase with no definition would be tucked in to the phrase robocall. The big difference, Mike, is not the artificial voice piece. It's the system that has the ability to store numbers piece, because this has the ability to store numbers, right? Your computer does. Every piece of telephony known to man does. Every soft phone dialer that's going to be integrated, right? Because it talks about software and hardware integrated with the computer has the ability to store numbers, right? Literally everything that you can think of has the ability to store numbers if it's a software-enabled dialing device, which these all are. So unless you're going to go to rotary phone, right? We're back in the rotary phone days. Unless you're going to the rotary phone, you are going to be using a robocall, period, full stop, except if the system, as you just read, requires the use of substantial human intervention. Now, you correctly said, what the heck is substantial human intervention? We don't know. There's no definition of that word either, right? No definition of that phrase in the statute. That phrase has never been defined by any court. So we are wide open, right? Completely wide open. But what bothers me is not that phrase. Yes, that is wide open. We got to figure that out, but we'll figure that out together. I'm not terribly worried about that. That word requires is in there, right? The system has to require substantial human intervention, whatever that means. And as we all know, this device does not require human intervention. You could put an app on this and push a button and away it goes, right? Or you could just let it run. Your computer, same thing. When you start talking about what's required, right, you get back to that capacity argument. Required when? Required in what sense? Required today? Required as configured? Required for my use? Required, what does that mean? So you've got two big, huge problems from my perspective with this definition. One, obviously, it's going to sweep in absolutely everything, as we just talked about. And then the only exception to absolutely everything is that everything has to require, whatever that means, substantial human intervention, whatever that means. And so we're back to a position where nobody is safe again, unless you're using a rotary phone, which nobody does.
Okay, so is there no precedence around an iPhone, use of an iPhone or a computer to make a manual dial or any type of technology outside of what we would consider a telephony platform or SaaS platform that has a automated dialing system in it? Has that not been tested at all in the courts?
Well, it has been tested under different iterations of the ATDS. And I don't want to give you the whole huge history lesson, but you might remember in 2015, the FCC did something goofy and expanded the ATDS definition, just like this bill might. And the courts were looking at things like iPhones and trying to determine whether or not it meets the definition. And the court said, you know what? It does meet the definition. And ultimately, that was why that ruling got thrown out by the appellate court, as the appellate court looked at what the FCC did and said, you're governing iPhones, like you're governing smartphones. You're turning us all, in the phrase of the DC Circuit Court of Appeal, you're turning us all into robocallers in the waiting, right? TCPA violators in the waiting. We don't know that we're violating the TCPA when we pick up, when we call somebody, but we are under the FCC's ruling. And this robocall bill looks to be the exact same thing. So if this passes, no, you are talking about a scenario where the courts will have no problem finding that this device right here in my hand meets that definition. No question about it. So the only question then.
Well, maybe I didn't understand you. I thought you said that the Supreme Court or the whatever it was court struck it down, that this wasn't, that they shouldn't be regulating your everyday cell phone.
Correct. Under the old definition.
On the old, okay. So this is like a reset. We have to go through that same process again to define this, or that precedent does not apply at all moving forward.
Would not apply at all.
Wow.
So that precedent applied to what the FCC did in expanding the old definition, right? It basically, what the court said is Congress didn't say what you're telling us that Congress said, FCC, and what you're doing is irrational, it's capricious, it doesn't think about the consequences. This is now not the FCC acting, this is Congress acting. Congress has more power than the FCC. If Congress passes this bill, the only test will be, is it unconstitutional? That is an issue, folks. That is an issue. But no, so all that precedent that came before looking at the FCC's ruling would not apply to this bill. This would be a live, valid bill until someone struck it down, if it became law, right? Right now, it's just a bill. It has not passed. But if it passes, all the precedent that came before would be out the window.
So is the only course of action, if it were to come law, is to take it through the court system for it to be redefined or defined through the courts?
Yeah, if this becomes law, right, which of course Reach and others are going to fight and lobby against, but if it becomes law, folks would have to really make sure that any outreach mechanism that they're engaging in, they've got that required express written consent, or that they're using like really sophisticated dialing systems, like like a human selection system, like a Safe Select or something, because anything else, you're at risk. And what will happen is people will get sued. And the plaintiff's bar is very sophisticated. They're very smart. They're going to do this incrementally, right? They're not going to file a suit with the guy using the cell phone right away. They're going to file a suit against the guy using the power dial, and then the preview dial, and then the click to dial, right? And they're going to get those rulings one by one and kind of work their way up to like the grand crescendo where, surprise, everyone is using an ATDS every day or a robocall every day. They're very clever. They're very smart. And of course, they're going to avoid guys like me, right? We'll defend companies. And if I'm your lawyer, you're not going to get sued for these theories. They're not going to try to make that precedent against me. They're going to make it against, some knucklehead that doesn't know what they're doing. And these guys are very predatory. They're very intelligent and strategic. So that's how it'll go down.
Yeah, you have an article that may answer a little bit of this about what your suggested changes are to sort of shut down robocalls. I believe it's on tcpaworld.com. I don't know the exact title of the article if you recall it, but I think you
Well,
know
the
what I'm talking about.
solution. The
Is it?
solution.
There you go.
Yeah.
Appropriately titled the solution. So people should check that out. But what do you think? With Bo Bratton here, his question: what do you think the goal of this proposed change is? I mean, what do you think they're thinking here for this? Put your tinfoil
Well,
hat on, as he said.
it's tough to know because it's so poorly written that I'm not trying to be mean when I say this. Like, I really don't know what they're thinking. I assume that they're trying to regulate auto dialers in any form or capacity, right? And they always want to try to create these broad bills because technology moves faster than the law can keep up. So they want to do something that's broad and like looks out to the horizon. And I get it. But there's so little technical expertise in Congress right now. These people are not lawyers by and large who are in Congress because we keep electing people who aren't attorneys and they don't understand how the law works and they don't understand what's going to happen in the courts. And they come up with these ridiculous bills because it just seems right to them. In the old days, like in the 60s and 70s, like Congress was full of lawyers and they would bring in experts and they would actually hear from people and like gather information and then draft intelligent bills. These days, as you guys see, like day in, day out, Congress comes up with garbage. And this bill in particular is so bad that I sincerely, and again, I'm not just being a jerk here, I sincerely don't know what they're trying to do. I think it's we want to ban auto dialers unless you have express written consent. I think that's what they're trying to do, but that's not what they're doing.
Okay. All right. Along with this, in there is also section 203, which is disclosure required for telemarketing using AI.
Right.
Tell us a little bit about that.
Yeah, so that's the big modification I mentioned at the top of my remarks here. First time ever. Those of you that attended the Law Conference of Champions, or the Troutman Amin event, not as good as Contact.io, by the way, but more of like a legal event that we had last year. Tori, the AI queen here in our office, gave a presentation about AI and said, look, there's no regulation right now requiring you to disclose if you're using AI, but that will change in the next year. She predicted that. And sure enough, here it is, right? And what the requirement is, it's very, very vague and it's very, very broad, right? So not a lot of loopholes here. They're just trying to make it as broad as possible. If you're using any form of AI, any form, right? Any ML, machine learning, any of your large language model, any of the whatever else is AI out there, I don't even know. You must disclose to that consumer as part of that outreach, right? So you're going to do like a telephonic outreach or even a text message outreach, right? Any outreach that's powered by AI has to now disclose to that consumer, this is Bob, your AI agent, or whatever it is, right? Whatever you think. I mean, you're going to have some latitude here. You're going to have the ability to be creative and come up with some good consumer friendly, something to help that consumer to wrap their arm around the AI and be friendly with it. It's going to be up to you to kind of fashion it, but you're going to have to disclose to that consumer in whatever way you choose that AI is being used for this outreach.
Okay, that's interesting. So you just have somehow they have to be aware that what they're talking to is AI.
Correct.
Okay. What I thought was somewhat interesting, because I feel like AI with phone calls, I think the industry already sort of wraps that into sort of a robocall, in the past. So I think those that were doing those sorts of things were already sort of disclosing that this is an automated call or robocall, something like that. But what I thought was interesting really was text messaging. Part of it says, if a person makes calls or sends text messages with respects to telemarketing, well, that's interesting too, and uses artificial intelligence in such call or text message to emulate a human being. So the call thing is interesting. You have an automated call, but the text messages, there's automated text message responses. There's all sorts of things that go out now that seem to need this disclosure, because a text message is emulating a human being, which I think that's a little confusing too. What kind of text message is emulating a human being and which ones are not?
It's a great question. Now, so that provision you're reading, by the way, that's limited to telemarketing, that is a TSR edit. The 203 section is TSR. There is a section, though, on the TCPA, and that applies to marketing and to non-marketing. So just keep that in mind. But for our purposes, your question is, what does it mean to emulate a human being? Man, I have no idea. I have no idea. I would guess, though, that most judges are going to say if you're using conversational AI in either voice channel or text, you're emulating a human being, right? That consumer thinks they're talking to a person. It's not like a waterfall IVR flow where the consumer understands that they're talking to a little bot and you're just pressing 9 to communicate. You're using language model, you're using typical English and slang or whatever, and this thing is picking it up and interpreting it and responding to you. That's going to be treated in all likelihood as emulating a human being. Now, we don't know that for sure, but that it looks to me like that's going to be the rule.
Okay. So how has that changed? Just give me a sort of reference as far as text messaging, because, I think 12 months ago, the message was, oh, yeah, you can text message anybody. Correct me, please. And then now it's sort of evolved into, no, you can't text anybody if it's related to business or automation or whatever it is. Clear it up for me. Clear it up for me. Where are we at with text messaging?
Yeah, I don't think text messaging rules have changed that much, to be perfectly frank. So a year ago, what I would tell you is that, text messaging is the safest channel at the federal level, and it creates risk at the state level. And as long as you're not using an automatic telephone dialing system as currently defined, then you are not violating the TCPA when you're sending text messages. Be safe, use human selection, but generally speaking, text messages are going to be okay at the federal level. Today, that is more or less the same thing, right? Obviously, you still have the DNC rules that apply to a text message. That was true a year ago. It's true today. The FCC just confirmed that. And the ATDS definition has not yet changed, nor has the AI disclosures come into requirement yet. So today, the text message rules have not yet changed. Tomorrow, right, when this bill passes, if this bill passes, then yes, there's going to be a massive change to text messaging, as we just discussed, right? Any AI-driven text messages is going to have that disclosure. And basically, any text message is going to become a robocall now, based upon the broader definition of robocall. So the only real change is that the FCC has now adopted a requirement that texts are calls for purposes of DNC protection. But truthfully, the courts had already found that. So I wouldn't characterize that as a change from a compliance standpoint. Although for litigation purposes, we are arguing to the courts that, hey, the FCC just clarified for the first time that this is the rule. That means it wasn't the rule before. But for compliance purposes, we would have always treated that as the rule.
Okay. And just a reminder for those that are listening, see you guys are all commenting and exchanging conversation in the chat, which is awesome. If you have questions regarding what we're talking about, please, put them in here and I will get them answered for you. The other thing that I found, wait, first of all, you just said something, which is this potentially going to be brought to a vote tomorrow? Did I just hear you say something tomorrow?
No, not tomorrow. No? Tomorrow, okay. Like in the future. Now, today was the open meeting from the FCC for February, and they did adopt a new set of rules, which we haven't even talked about yet, which are the revocation rules, which are yet another change to the TCPA right now.
Okay, that's perfect segue, because that's exactly where I was going with our next thing. I love it. Which is, yes. Okay, so now let you just go for it. They just changed how people can sort of opt out, right? So explain.
Yeah, so really, guys, really big change, very, very nuanced. And this is a moment where I'm going to say, this is one of the topics where you want to attend a conference and hear me talk about this for 45 minutes in isolation, right? We've got the big March conference coming up with DNC.com, the summit in Arizona, Contact.io. I'll be out there talking about something like this. Of course, the Law Conference of Champions. You're going to want to hear me break this down, okay? Because there's a lot to it. At a high level, all the rules around revocation have changed, okay? Today, the FCC confirmed that you no longer have up to 30 days. You only have 10 business days potentially to honor a revocation. However, you have to honor that revocation as soon as practicable. So if you can do it in 24 hours, you have to do it in 24 hours. If you do it in less, you have to do it in less. The consumer can now revoke consent in any reasonable way. The FCC has rejected the idea that you can have a contract term that states how revocation takes place, which is a huge change, because the law used to be that you could absolutely have a contract that says you have to revoke consent in this way. You can have a disclosure on your website requiring that, but now you can't. And that's going to be challenged in court, by the way. I don't think the FCC has the ability to cut down on private contract in this way, but that's something that's going to be regulated and looked at. Maybe the biggest change, though, and again, this is nuanced, is now if you send a text message that is a marketing text message, and that consumer says stop, you have to stop all of your automated outreach to that consumer unless you have an exemption of some kind, okay? An exemption from consent. Informational texts have to stop, just the same as marketing texts and calls. Huge change, guys. This is absolutely a massive change. Yesterday, if you send a text message that's a marketing text and that consumer says stop, you have to mark them on your DNC list for marketing purposes, but I would have told you you could keep on texting them for informational purposes and calling them for informational purposes. According to the FCC, you no longer can. You have to stop. Now, what you can do is send a one-time message at the end saying you're opted out, but if you want to continue to receive informational messages, press 9 or something. If that consumer does not press 9, you have to stop. Now, that's a huge change. That does still allow you to pivot to a manual, right, like a human selection informational outreach, although you still have to treat them as DNC for all marketing channels. Okay, so that's one massive rule. Again, nuance here. Second massive rule change. If this was an informational text, this is going to blow your mind. If it was an informational text that the consumer texted stop to, guess what? Now, all of your rights to send communications to that consumer have been taken away, even if it was subject to an exemption. Even if you wouldn't have needed consent, you can no longer send those messages to that consumer. This is a massive change. Again, I'm not sure that the FCC really understands what this is going to do to enterprise, right? I mean, our small guys, the lead gen guys, it's going to impact them. But man, the Wells Fargos of the world, they are about to lose their mind. They're about to lose the ability to contact 90, 80% of their customers, and they're going to have to become really, really reserved in terms of how they're going to communicate. Because today, somebody says they want to stop an alert from ATM withdrawal notifications or low balance notifications, and boom, you just lost the ability to communicate with them when they go into default on their mortgage. This is nuts. I mean, it is crazy, and I guarantee you the FCC did not think about this.
So this is like the no means no. This is it. No means no. I don't want any of it. And it is crazy. So that's a perfect example how crazy it is. If someone's getting a marketing message from a bank and they say stop, now they're not going to get their fraud alerts to text message or anything.
Well,
like that.
now a fraud alert would be an example of if it's a marketing message, they could still get a fraud alert. They could still get a fraud alert. But if it's an informational message, fraud alerts are gone too. So again, if it's a low balance notification that the consumer says stop to, now the fraud alerts are gone. If it's a marketing message, the fraud alerts could still continue because those are exempted, but not a low balance notification or a collection call. Those would have to stop because those require consent.
Okay.
I told you it was new. I told you.
and that includes email as well as chances confirming.
Today, no. Today, email could continue. If the Do Not Disturb Act passes, then email might be part of a definition of robocall in the future. That would have to be litigated. But today, you could still email.
Okay. It sounds like, how regarding email, how people will opt out of a list and you get to that opt out page and goes, do you want to opt out of newsletter? Do you want to keep, do you want to adjust your subscription or whatever the heck it is you want to call it to these certain messages? I'm guessing if that's that one response that is going to need to go out, right? To confirm, hey, do you want to opt out of all things or just text 2 for all, text 3 for this? I don't.
I would definitely leave email out of that last confirming text. I would not even touch email.
No, but even if it's just text messaging calls, it's that option to go, okay, are you sure you want to opt out of everything or just these messages, that toggle opportunity?
I will say, I mean, the FCC now in kind of dropping the hammer on everyone, no means no, does create an opportunity for really creative people to come up with some great little, hook at the end to bring people back in for at least some form of communication. The commission is very vague, as you'd expect, in terms of what that message can contain. The only thing it's clear on is it can't be a marketing text, right? You can't say, hey, but we're awesome. Come back to us, baby. You love us, right? Which is what you'd want to say. You can't say that. So you have to say something informational that just kind of clarifies. And this is, by the way, I'll give a shout out to Jeremy Gladstone over at Capital One. He was the guy that actually brought the petition asking the commission, like, hey, if you're going to shut this down, on the revocation side, can you at least give us the ability to ask the consumer to clarify which channel of communication they still like, if any? So they got this done for industry. That's nice. Good job, Capital One. And now we'll just see how creative people can get in terms of being non-marketing, but bringing people back into the fold for at least some forms of communication after they opt out.
Okay, we're going to get to, I think, a really scary part of this. But first, ringless voicemail is included as a robocall, right?
Yeah, that's
Yep.
easy.
Okay.
Ringless voicemail has already been defined multiple times to be a robocall, and that's not going to change.
Yeah. Okay, so what I thought was a little scary was the second point, at least on your blog, which is FCC determines using the word stop, quit, end, revoke, opt out, cancel, or unsubscribe via reply text message constitutes a reasonable means to revoke consent. But here it is, the scary part to me. This does not preclude, however, the use of other words and phrases to revoke consent.
Isn't that awesome?
So now we're just like, okay, these are the words, but there could be 100 other words that you can get in trouble for if you don't know what they are, you know?
You are correct. I mean, so the FCC gives, the white label treatment or the black label treatment. I'm not sure that if you're using these words, boom, this is for sure a reasonable way to opt out. You as a business have to honor this. It would have been nice if that was it, right? If it was like some kind of balance, some kind of deal. Yeah. Like, here's the deal: consumers, you can use these words. Businesses, you have to honor these words, but that's it. Nothing else. No, of course, the commission couldn't do that for us. So it says, if these words are used, business, you are done. You're toast. You have to honor that. But if the consumer could do whatever they want, right? Any reasonable means, right? That's the test. Any reasonable means. So, and we've seen this before, right? These opt-out evaders, the people that are like, it surely would be great if we could limit the number of times when we receive messages, but never say stop or quit or anything like that. The commission has in the past said you can't use imaginative means of opting out. This particular ruling had none of that ameliorating language. There was no kind of chastising of consumers to behave themselves, as we've seen in the past. The courts have been pretty good, though, about being like, dude, you know how to say stop, knock it off, right? But businesses do need to be on guard, because if it's a clear request, like knock it off, like leave me alone, those are going to be treated as revocations, even if they don't use the magic words.
Yeah. Okay. I think we covered at least what I know, or what I was most, concerned about, which was the AI robocall definition, the revocation disclosures, text. What are we missing? Anything else?
Well, I think it's worth noting, people should already know this, that AI communications right now, right? Again, the disclosure requirement that we've talked about is not law yet. However, via the FCC's new ruling last week, AI messages, AI voice, generative AI voice channel is being treated now as a pre-recorded or artificial voice under the statute, which is not a surprise, right? We all should have seen that coming. That was something that we gave guidance on, and not just us. Most of the time, Troutman Amin is at the forefront. We're the only one saying something. This was so obvious. Other law firms were saying this too. Like this, we all knew this was coming. So we just have to emphasize it again. If you are using generative AI voice for any outreach that is a voice AI platform, that is a pre-recorded or artificial voice now under the TCPA. You have to have express written consent for that technology for marketing purposes and express consent for that technology for all other purposes.
But you also include text, though, not just for a call.
Text as well, but not, no. Text messages are not pre-recorded voices. They are not.
But they're artificial. They're
not. They're not. Okay. So text messages are not treated as voice. Text messages are text communication. So a text message is only subject to the regulated technology provisions of the TCPA if they're sent today via an ATDS, right? Now, the DNC provisions, everyone has to remember there's two provisions of the TCPA, right? There's the DNC provisions, there's the regulated technology provisions. The text message is a regulated technology only if an ATDS is used. A AI voice channel is always regulated technology now. But either way, if it's for marketing purposes, the DNC rules are still going to apply to either text or voice communications for marketing purposes.
Okay, so where am I getting confused, Eric? Probably a lot of places. But It was under the Palone's proposed robocall
Yes.
definition.
Palone's proposed definition would change everything, right? So we're
Okay.
talking about today, right?
Yeah, yeah,
Today.
but tomorrow. So tomorrow, and give us a more specific timeline as what tomorrow may be.
Well, unfortunately, this bill appears to have legs, and I know so I knew about this, that this was coming out in December. Like, I knew it was coming, but everyone had so much on their plate already that I didn't want to like start bombarding people with, hey, by the way, something's coming out of Congress. So it came out, and it's, I'm being told by multiple sources that this has got legs. Palone's standing behind this. Others are lining up to back it. That does not mean it's going to pass. It does not mean it's going to pass without being edited. It just means we've seen other bills. I've just come right out. You guys have heard me say, I've come right out. This has no legs. This will not pass. I'm telling you it's there so that you know, but it's nothing. This bill is something. Okay. Again, that does not mean it's going to pass, but this bill we're going to be living with. So it is conceivable that it really starts running. It's in committee right now. It gets passed out of committee, and it hits the House and could get voted on in theory in 30 days, right? In theory. Now, there's no complementary bill in the Senate right now. To me, that's what you're watching, right? If you are really interested in this, right, the Senate has not proposed its own version of the bill yet. Once that happens, that's a massive signal that this thing is going to become a law, right? For now, it has legs in the House, right? There's a lot of chatter around it on the Hill. They're talking about it. I'm going to be very watchful in the Senate. If I see a complementary bill there, I know, okay, we're in trouble. What I believe is going to happen is the AI disclosure that is going to pass. So that's going to become law. The robocall definition, I believe it'll be modified. I don't know if that's going to become law. The text message definition, I believe it'll be modified. I think it will become law, but modified. So we're going to see some change, but I don't know if we're going to go full Monty to the robocall definition.
Okay. And if people want more information about what we're talking about right now with the Palones, you can go to tcpaworld.com. Put it up here again. Not that difficult, but there it is. And on January 29th, Eric posted a article, massive proposed TCPA changes hit Congress. Take a look at that. Really good, probably clearer than me making it so confusing with all my questions. Article there. So check that out. I should have had the link for you guys ready, but it's was posted on January 29th on tcpaworld.com. So go check it out and go subscribe to the dang website if you really care, because everything is, I mean, Eric and Pooja do, and their whole team do an amazing job at posting articles literally in real time when things are happening. So you got to know, you got to be a part of that newsletter as well. And then subsequently also be aware of Reach, which is fighting for the industry when on behalf of the industry when these things come up. And have you guys in mind. So if you're not aware of that, I'm certain there's information on that on the website as well, or just go to reach.com. No,
Reach MBC. MBC. It's a mutual benefit corporation, so it's reachmbc.com.
Okay, cool. ReachNBC.com. Let me just check questions one more time real quick. Oh, good. Jennifer, thank you. Awesome for posting that in the comments. The link to the article right there. So thank you, Jennifer. Outside of that, I think we could leave it there for now. I will keep in touch with Eric on the happenings with this with this proposed changes. If something happens, you'll certainly be the first to know if you're subscribed to TCPA World. But if you're just a friend of mine on LinkedIn, I'll make sure to bring Eric on as soon as possible. So again, I can ask all the dumb questions and he can answer all the smart, give all the smart answers. So I appreciate everybody for participating today. Thanks again. Any final words? I don't want to cut it off short if there's something you want to leave us with.
Well, I think, we ought to always remind everybody, right? The 1-to-1 ruling now being final, January 27th, 2025 is your implementation deadline. So we're off to the races. And then February 26th, so 11 days from now, right, is the cutoff on the NPRM for comments from small businesses that want to tell the FCC how bad this 1-to-1 rule is going to be for them. If you're a small business that's going to get wiped out or really hurt by this rule, tell the FCC. It is possible there's still going to be some modifications to this rule. We don't know that. I'm not promising you that, but that is possible if enough small businesses weigh in. So that is also something that people should keep in mind.
Okay, and where do they do that? Where can they submit those comments? If they're a small business complaining about the one-to-one and why that's bad, where can they do that?
Jen, can you put the link in right now? So TCPA World and Reach have resources available to folks. There's a template that is available on our website. There's also a step-by-step guide so that you can access the FCC's portal and submit these comments without even having a lawyer. Obviously, if you have a lawyer, you work with your attorney. We're happy to help you as well, but you don't need one for this. Like, it really is just like, hi, I'm a small business. I'm going to get wiped out. Here's why, and please help us, right? That's just all you have to do. And it's really very important. So Jen, if you could just pop that up, there it is right there.
Thanks,
this will help you. This will help you to have your voice heard with the commission.
And how awesome is Jennifer? Seriously, hooking us
She's
up
amazing.
with the links. Thank you so much for doing that, Jen. All right, cool. Well, listen, I will leave it at that. Thanks, Eric, again. I'm glad you made it to work safely and made it to work in general with the ride with Pooja. We got to make sure you have a safe trip here, to work. We can't lose Eric Troutman. You know what I mean? Or Pooja. I'm just kidding. Both of you, we got to be careful. So, all right, I'll leave it at that. I'm going to shut up. Goodbye to everybody. We'll see you later.
Appreciate it. Bye, everyone.